welcome all of you out to the Planning Commission for Kaysville. Looks like we've got a conditional use permit for a major home occupation for B. One is for an eyelash extension at 1071 South Kays Drive.
Yeah, so as introduction, Madam Chair, and for the Commission, Ms. Hayes requesting the conditional use, as stated there, for eyelash extensions. Her property in your packet and located on the map, if you'll pull that up, is just on the south end of Kays Drive. She has stated that her business would essentially expect to have clients come by appointment no earlier than 7 and no later than 6. And typically those appointments, depending on the specific services, range an hour to 2 hours or so. Based on the discussion staff's had with her and a review of the ordinance, we're recommending approval as proposed without additional conditions.
Is Lorene Hayes here? Would you like to come up if we have any questions? At least we could meet you. Do you have anything that you would like to add to that, or I'll open it up for any questions?
Seems pretty straightforward.
Yeah, okay. Great. Take a motion.
I move that we grant a conditional use permit for major home occupation B for eyelash extensions for Lauren Hayes at 1071 South Kays Drive.
I'll second. Aye.
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 Aye. Aye.
Thank you. Congratulations. Okay, we have dog training at 299 West Clover Meadow Road for Jason Robbins.
Okay. Again, as introduction, Mr. Robbins' request is a little bit more unique than the previous application. We see several of those. But his home, as you can see here on the end of the street off Clover Meadow Road, is near, I think it's Fairfield Junior High fields right there in the to the east of it. He does dog training. Typically it's a one-on-one with one dog at a time. But he also teaches owners and others who are interested in his techniques on how to implement those. Probably something I could use someday with my luck with animals. But in any event, it's generally those one-on-one or small group type scenarios. However, he does expect that once a month there would be a larger group that comes to the home, multiple dogs who have been through a certain stage with the courses, and maybe let him speak to that if there are further questions. But based on that, staff's recommended approval based on our understanding of the request with two, sorry, I feel like I'm pretty quiet, with two specific conditions. So the one condition, because it's a group class, the way I've felt it fits best within our ordinance, it is required to have a limit placed on either students or vehicles. And so we chose to go with vehicles, limiting the number of vehicles on a regular basis to no more than 3 cars at a time for the clientele, but then to allow an exception once a month for up to 10 vehicles for the 1 hour big group deal when they do that. The second condition we're recommending from staff is just to limit how late the classes can go in case the dogs decide to get yappy. So the recommendation was to not allow anything after 9 p.m. And with that, I'll return it back to the commission. Happy to take questions, and the applicant is here as well to answer any questions.
Thank you. Thank you for coming up. Do you have anything to add, or will?
I'm just excited to bring this level of dog training to Kaysville.
I know. Do you do large and small dogs? Or? Okay.
How did you get to be such a trainer?
It's a long story, but but mostly I love training animals.
Just have experienced it.
I did an internship with another dog trainer.
Mm.
Went from there.
That's great.
It's mainly obedience type training.
Advanced obedience, yeah.
Okay.
Mm.
Just a couple of questions. The staff report didn't mention what time you'd be training. It says you've got a full-time job, and so this would be after hours. When would the training happen?
I have a full-time job, and I teach school. So that's mainly it's not the dogs you train, it's the people, right?
Uh-huh.
But so it fits really well. The training mostly takes place for me when I train certain sessions would be between 3 o'clock and 6 o'clock at night. I talked with Lyle right before and said 9 o'clock never happens. Like we never take it that late because I have a family too. So.
Then with the group training, how many dogs would you have in the group?
At times, I think the biggest one we've had is about 8 dogs at a time. And it's offered just as an ongoing support after the training has been fulfilled. So it's dog trainers that have, or handlers that have the same rules and dogs that have the same level of obedience. So we can take a group of dogs, 8 dogs that have even in the past been aggressive, and they can all be together and do some pretty amazing things.
All right, thank you.
Thank you for your question.
Do you have a fenced area outside, or are you doing it in your home?
You can kind of see to the west there that there's a large carport, and that carport has a fence around it, and that's where we do a lot of that. Sometimes we do it in the driveway right there in the front. As far as the group class is concerned, is that what you mean? Or do you mean the training itself?
The
training itself would happen there in the driveway or inside the front room of our home.
Okay, thank you.
Do you promise to pick up from in front of the neighbors' yards?
If it's from my dogs.
Darn.
That was a good try.
Okay.
I'll make a motion that we grant approval for conditional use permit for major home occupation B dog training for Jason Robbins, 299 Clover Meadow Road, with the condition that they do not take place after 9 p.m. and with limited number of vehicles based on staff recommendation.
I second the motion. Aye.
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 Okay, thank you.
Thank you.
Okay, we have another conditional use permit for an interior design at 1352 South Sir Barton Drive for Kim Caldwell.
Okay. Again, Madam Chair, our final home occupation of the evening. The property for interior design as a home business on the corner of Sir Barton Drive, just right off of Western Drive. You can see there in your packet, and again on the map here on the slide. If pop that up. And Ms. Caldwell has had a home occupation here for some time, just as a minor home occupation. She's been licensed with the city operating as that, but is starting to see some growth and changes to that. And so we'll continue to offer interior design service. Sometimes it's on site. Oftentimes people will now come over to get a consultation. And as part of that, where it also ties into a major home occupation, there are deliveries that will come periodically as she designs a room, a certain item required to implement that design. We'll order that and then deliver it from her place to the customer's home. So based on the visit I've had with her and my understanding of it, having gone over the ordinance, staff is recommending approval without conditions beyond what's already restricted within the ordinance.
Thank you. Is Kim here? We always like to meet you. Come on up. So you've been doing this for a while?
Mm-hmm.
That's good. Any questions?
Sounds really great.
Thanks.
I mean, if you're growing, that's a good sign, huh?
Yeah, it's been a good year.
So do you take appointments?
Yeah.
Okay. Do you have a showroom and that in your home?
I have some pieces in my home that I show, but I don't have like a setup. Some of my furniture is some
Okay.
stuff that I sell, but I don't have like a specific area set up as a showroom.
Okay.
No questions.
Okay, good. Take a motion.
I move that we grant a conditional use permit for a major home occupation B interior design for Kim Caldwell at 1352 South Sir Barton Drive.
I'll
Second.
Oh, go ahead, Tom.
Second.
Aye.
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 Okay,
Thank
thank
you.
you.
Thanks.
Okay, we have a final plat approval for Whisperwood subdivision at 650 East, 100 North for Spencer Prince. One thing that I wanted to say, we've had this before the commission before, so I would like to give each side 5 minutes to state their position, and then we can take a vote on that.
Okay. So we have 5 minutes then. Okay. As you know, prior to this meeting, the street vacation was approved. Vacating the street was approved on May 18th by the City Council. The Planning Commission approved preliminary plat on May 25th. The City Council approved preliminary plat on June 15th. And then you're all aware of the last Planning Commission, and very understandable that there was not a quorum when it got to me. I would like to.
Could you speak into the microphone just a little bit closer?
Is it on? Yeah, it is. Sorry. Tonight we are here to make sure that we have complied with all of the requirements that were given to us by the Planning Commission. There were 5 requirements: access to Briggs property resolved, stormwater problem addressed, privacy concerns be addressed along the western property line, work with staff to be determined if a geotechnical report is needed, and lot number 6, not included in the PRUD. That was already done. That's not included. 3 main things: the water and essentially the west property line. Mr. Thompson, could you please just bring up a top view of the west property line? While he's doing that, we have determined to utilize Ready Rock for the retaining wall. There's a couple of files that he can show on that. We've got pictures of 2 different types, cobblestone and limestone. Either one is just fine with us. Maybe just bring up. Yeah, that's the cobblestone. And then if you could bring up the picture showing, that's fine. And then the west property line. So as not to waste time while he's bringing that up, part of the requirements were to make sure that to see if we needed a hydrology study. Okay, yes, right there. Sorry. Right here is the west property line. We're doing a Ready Rock retaining wall. On top of that, we will be doing a 6-foot fence that matches the property owner's property, and then planting trees. Can you show the, I think it's called west property line with elevations? It was determined, and we determined to do a hydrology study. Okay, this is a picture of the west property line. This first line is the height of the retaining wall, just above the height of their foundation wall. Of course, it slopes up, the ground slopes up. Then this is approximation. This is approximately the height of the fence, and this is approximately the height of the trees, blue tip spruce that we're planting when they're full grown. They grow to be 8 feet diameter and 12 to 14 feet high. That's a 12-foot high to show there, and we did that due to give privacy. We have stayed within all of the requirements of the city as far as staying away from the home, the 20 feet. Then we do the road of 24, and then the setback from the properties. So the closest home to that will be to that home will be 64 feet away. Okay, then if we could do a number 6 if you have that. As I was mentioning on the hydrology study, we did hire a specialized engineer. He studied the 28-acre basin that flows into this area. And it's okay if I'm jumping back and forth. Is that all right? Okay, this is showing the property owner. Mr. Briggs owns this home. These two, the yellow was the property that he purchased. This is the right-of-way for the street. As we said, that was vacated by City Council. It won't be finally vacated until final plat approval. But on either side, there is not sufficient space to build a home. Would you go to the next slide, number 6? This is what he will ultimately end up with, and he will not have to be part of the homeowners association. He'll have cross easement, and he can build 1 or 2 homes, whatever he determines on that. Just very quickly, if I may, the water situation. This slopes to the east from here. This is an engineered waterway that takes all of the water up to a retention basin. The retention basin
document that I was going to read some highlights from. I'm Alan Bachman. I'm with the law firm of Fetzer Simonson, Booth and Jenkins, and I'm here representing Matt and Valerie Briggs, who have property abutting this. So I wasn't planning on submitting this in the record, but I'm going to, it just got submitted over there. And they're going to make some copies. I was an attorney for a planning commission for about 9 years in Oregon. A lot of times we were up till 2 or 3 in the morning going through subdivisions. And so I personally want to thank you for your time and the fact that you do this kind of work. It's often goes unthanked, and just want to make sure somebody at least thanks you. So I want to make that clear on the record. But sometimes you might think, well, this has gone on a long time, but it really hasn't, because this latest plat that we're seeing, we've only seen for the last couple weeks, and we've asked, at the last meeting we were told that we would be able to see the engineering data and drawings and other materials to be able to review it so we could be ready for the meeting today, but that didn't happen. We were denied access to it. Doug Farr, another attorney here, will be speaking more to that as he's representing the Taylors. And then I was told that maybe perhaps yesterday we would be able to see those drawings. Well, that's not enough time to have our own civil engineer take a look at it and be able to make sure that the water situation and other issues that we have are taken care of. So we're not NIMBYs. We're not here to try to stop the developer from being able to develop or being able to maximize, frankly, the amount of money that this person could make on the neighboring property. We just want to make sure that it's not a mediocre development, that it really does meet the criteria of state law, including the vacation requirements of a road, as well as your ordinance requirements, so that proper findings of fact and findings of law can be made. Findings of fact and findings of law, because the Supreme Court came out with a case in September. You may not be aware of it. It's McElhaney versus the city of Moab, and basically overturned the decision for not having those proper findings. And in order to have those proper findings, we have to have due process. We have to be able to see the data, and you have a staff report. I think Andy Thompson's a great man. We've met him several times, but I don't think you have the information and the data and explanation of how I'll go 4 out of the 5, the 5th one's met, how 4 of your criteria that was indicated last May for final plat approval has been complied with. And certainly the neighbors have not had their due process rights complied with by being able to see the data that shows, in fact, that they will not be affected. And I'm going to cut this short I'm going to begin with the end in mind, and then I'm going to go through some of the issues here. the end in mind to really resolve this so this isn't held up beyond the city council into the courts, and we do really get a development here that makes everybody happy, and including Mr. Prince, is we're probably going to have to end up before a neutral mediator at some point. Once we get the data and the information, we find out what's going on. Some of the issues may go away when we see the data and be able to review it with our civil engineer. Some may not. I don't know. But there's a serious constitutional issue with the road issue that may be able to get resolved. But that's what I think, that's the end in mind, is that mediation with a neutral mediator so that the development doesn't get held up for a long time. So that was the end of it. So I already mentioned the fact that we've had a problem getting the data. One of the conditions was that access to the Briggs property be resolved. Okay, and I have to be honest with you, we're looking on the website, I had a hard time until I met with the Briggs recently to understand how they do have access. It appears that this parcel 1 is going to be granted to somebody. I'm not sure if it's to the city. I'm not sure if it's being granted as an easement to the Briggs or what's happening with parcel 1, but it doesn't align with 100 North Street. Apparently it goes into another road, and I don't know who owns that road. And so the Briggs are very concerned about the provisions of the Utah Constitution, which is a little different than the United States Constitution. The United States Constitution says you can't take property without just compensation. The Utah Constitution is actually a little stronger in that regard and says that you can't take or damage property without just compensation. And so we're very concerned about whether that's been met, and that was your first condition that you laid out last spring. On the stormwater problems, maybe that has been addressed, but we don't know till we look at the engineering data and able to look with our own civil engineer, which we think, you know, homeowners that have invested a lot in their homes and live in Kaysville, you know, they want to know for certain that they're not going to get flooded, and they can trust, you know, what the developers, engineers have done. That's an appropriate check and balance. The privacy concern, I'll let Mr. Farr address that. The geotechnical report, that was one of the conditions. I don't know what happened with that condition. I don't know if there's been some testing that's going on there, some geotechnical testing, and what's that shown in terms of the soils, what's going to happen to the road, what's going to happen with the one home that's in that very low area you just saw a little bit ago on the screen. You can see there's quite a dip there. So that's a real concern, and these neighbors, they live there, so they sort of know the water issue. But on all these, the point is eventually has to go to the city council, and it eventually has to end up with an order with findings of fact and conclusions of law that allow a court to be able to review it properly. And that's what the Supreme Court says in that case. And if it doesn't end up with that particular document, then it gets kicked back, and we've lost a lot of time. And that's why I'm suggesting the mediator solution for that. You have very good ordinances. Your subdivision ordinance and your ordinance on PRUD clearly talks about making sure that developments are compatible with the neighborhood and not creating deleterious impacts in the neighborhood. And I think that's very good. You know, once again, we don't want just a whole clamor of neighbors saying we don't like a development. That shouldn't be a reason for holding up a development. Okay, that's not fair to a developer. But if there's legitimate issues and legitimate impacts to be researched and found out, then that should be worked on. And at least these neighbors, to their credit, they're not just saying, no, we just want this to be an empty field. They're saying we want to make sure that our homes and our property will not be impacted by this development. So a lot of this is laid out in the document.
Was that 7 minutes or 5, and we had 2 more?
That was 7 minutes.
Okay.
Yeah.
Thank you. In fairness, we
and
will.
So, yeah, I guess that wraps it up. And I hope you look at the document, the court case. We have a grandma request out there for more information. And I just encourage you that my experience has been that sometimes when things do get rushed, you actually lose time. Thank you very much.
Thank you.
Good evening, Doug Farr with Snell Wilmer Counsel for the Taylors and Tices. I want to be brief here. I don't want to take much of your time. And at the last Planning Commission meeting 2 weeks ago, I explained my clients were not interested in stopping this development. They just want it developed responsibly. And I explained that my clients had some serious concerns because they hadn't been given access to the documents. And after my remarks and after one of the commissioners had to leave for a family emergency, the developer came up and essentially accused my clients of trying to just delay coming in with some 11th hour tactics. I was brought in about a week or two before the last Planning Commission meeting after my clients discovered that there was this new plat and there were these new plans and they hadn't had access to them. And so we met with the city and the city engineer and went over those plans and said, we need to be able to look at this to make sure that these conditions are satisfied. The two conditions that matter most to my clients are the water concerns. My clients have had flooding in the past in their basement and in their garage that caused damage. The city spent, I've heard, $30,000 to correct those problems and only partially corrected them. And so there are some legitimate concerns. And I came to the commission and said, we need to see the plans. And the developer said, I will turn them over to them. I'll let them see it. And he said, we'll turn them over immediately. So the next day after the Planning Commission meeting, I sent an email to Mr. Prince and said, sorry I had to run out. I had a wife and baby in the parking lot, but we'd like, you said you'd turn over the plans, the engineering plans, the geotechnical report. We would like to look at that, turn it over to our expert so they can look at the water study and make sure the water concerns are resolved. We learned a lot at the commission meeting 2 weeks ago about the privacy concerns. That was the first time I'd heard about a fence or trees. And I had some frank conversations with my clients. If we get a materials list and this is what they're going to do, the privacy concerns are going to be resolved and we go away. But there's still concerns about the grading. They're saying the property slopes from my client's house to the property. They're building an 8 to 9 foot high retaining wall. There's no way, looking at the picture that he proposed to you, that the property will slope from my client's property to a 9 foot retaining wall. And water does come down from roads and through fences, under fences. We all know the problems with water. So there still are some concerns. So the following day I emailed Mr. Prince and asked him for the geotechnical report, the engineering plans, so that we could review them. On Monday, after not hearing from Mr. Prince, my office sent a grandma request to the city, expedited basis, asking for all of these records. On Tuesday, I believe, the city got back to me and said, we'd like for you to reduce. You've asked for a lot of information. Reduce it. So we just asked for the engineering plans, the development plans, the materials list, and the geotechnical report. And the city got back to us last Friday and said, these documents are confidential, and we can't turn them over to you. That was all we got in the denial. So I responded to the city recorder and said, the code requires you to provide specific provision of why you're claiming confidentiality, and confidentiality requires specific requirements, including that when the documents are turned over, they're marked confidential. And I said, and the city said, well, they're confidential, but you can go talk to Andy and you can go look at them. And so I said, if they're confidential, they're confidential. Either I can see them or I can't. So can you please get some clarity and provide a complete denial with all the information, and plus let us know whether these documents are confidential or not. The following Monday and Tuesday, I exchanged some emails with I spoke to the city recorder on Monday, and then Tuesday followed up with her again by email saying, please let us know on this confidentiality issue. Can you turn over the documents? And then yesterday, for the first time, Mr. Prince emailed me and said, you can come and look at the documents. You can't take copies. You can't photograph them. You can't have a copy, but you can come look at them. And he said, I responded to you through the city last week that you could see him, and which I don't need to get into that issue. I don't think he can speak on behalf of the city, and if he is speaking on behalf of the city and making decisions on behalf of the city, then I'm extremely troubled. But he did offer, and I said, look, my clients don't want to pay me to travel up from Salt Lake and the engineer that I have spoken with in South Jordan to drive up on an hourly basis to Kaysville to look at the plans and not have an adequate time to analyze them and do a proper review of the documents. Not only is this the day before the Planning Commission meeting tomorrow, but it doesn't give them enough time with the parameters you set up. And I responded and said, we will sign a confidentiality agreement, we'll sign a non-disclosure agreement. My clients have no interest in these plans. They're not going to develop this property. They don't want to do anything with it other than to review and to make sure the conditions are satisfied, that the water is not going to cause a problem on our property, and that the materials are appropriate for this 9-foot retaining wall and will not cause any issues there. We don't want a road collapsing onto my client's property. And I'd never heard back from that email. The same day, yesterday, got a formal denial from the city saying not that they're confidential, but that they're protected by copyright. And that's the first time we've heard this, that they're copyrighted. I don't know how a geotechnical report is copyrighted. The plans, there may be an argument there. We do have some rights, but we're willing to work with them. If they want to put parameters on it, we can do that. But it's adding cost and expense to my clients unnecessarily. We will enter an agreement that we're not going to distribute them to anyone or show them to anyone other than my firm, my clients, and our engineers that can review them. But my clients have the right to be able to protect their properties, especially because the city is vacating a public right-of-way in order to put in a private lane right next to my client's property when this property has had water concerns for years that have been recognized by everyone in this room. Now, we hear that they're solved. We have the right to be able to determine that. And we have lined people up to do that, and it costs money. And if it's right, then we go away. I'm not here to cause problems. My reputation matters way more than this, and usually I'm on the developer side when I'm at these meetings, 98% of the time, because most neighbors just want to complain to stop development, and that's not what we're here. We're here to get some protections that we're entitled to under the law, and also some peace of mind. So my last comment will just be that we continue to want to work. That's why I propose another solution, a confidentiality agreement. I'm open to other suggestions, but forcing us to come in the day before or come in the morning of this meeting and then drive back to my office and come back for this planning commission meeting just didn't work with my schedule, didn't work with, I didn't even reach out to the engineer because it didn't seem like a feasible plan. But we are committed to working this out, and I have been involved in litigation for an engineer who said in a neighboring city, do not build here. There are water problems. And what did the developer do? Go to another civil engineer and get a report that says it's fine. Well, then there was litigation because it wasn't fine. Unless the commission has any questions, that's all I have.
We'll call you back if we do.
Thank you.
Okay. That's a lot of information.
Could I just speak just quickly just to address a few issues that were brought up by the other parties, if that's possible?
Okay.
I also will not take very much time. My name's Kenny Brown, and I am from Smith Knowles and representing the developers in this. I just want to, I understand that with development issues, things become testy and contested. And I just want to make sure that it's clear that we just focus on the issues in terms of what are the problems that needed to be resolved and whether or not the problems were answered satisfactorily. And so with each of the issues, in terms of the Briggs property access, we have proposed an issue that resolves that. With the parcel 1, what we've proposed is to grant them a deed 30 feet of access so that the access issue in terms of the parcel is not going to be a problem, as well as an easement along the private lane. There shouldn't be an issue in terms of, we've never held out on that in terms of saying, oh, we have never intended to deprive them access to their property. And what we're granting there is extremely generous in terms of we're just going to outright deed the parcel to them in order to give them access. The other issue is with the stormwater problem. I understand that it's a problem, but we've had engineers looking at it, and to everyone's satisfaction, it's been addressed. And obviously, we are open to discussing and making sure and validating that information, but that has not been, we have responded with all due diligence in order to get that problem resolved. Privacy concerns, again, we have attempted to formulate a solution that we think is in everyone's interest. Obviously, we want to make sure that it is both structurally sound, aesthetically pleasing, and everything like that, but the proposal we've given, we think, comports with that. And so, again, I just want to make sure that it's clear that we have done everything that the city wanted us to do. We've been working with the city, and we try to resolve everyone's concerns.
When you made that statement to everyone's satisfaction, who's everyone?
I will say, in terms of, we have attempted to compromise in a manner that meets as much in the middle as we think we can do in terms of each of the issues that were brought up in requiring the preliminary plat approval.
Okay, thank you.
Thank you.
I do have a quick question. Either you or Mr. Prince could address. When we had our planning commission meeting a couple weeks ago, when the issue of them not having enough time to look to the engineering reports, we can't mandate or dictate that they give them to him. But I specifically asked Mr. Prince if he'd be willing to do that and give them to him. And he said, sure, I will. I'm wondering why, after I asked you that comment, and you...
Yes, you directly asked me.
And you said you would be happy to give them to them.
We would be happy to give them to them based on their intent. I went back and reviewed all of the councils and all of the planning commissions, and the intent is not to approve. Their intent is they do not want to approve this. They want to find a way to not approve this. They want us to develop it differently than it is. We have to conform to the preliminary plat. We had received counsel that of the privacy issues. I sent an email, and I did want the city to be there to know what the discussion was. We didn't have counsel. They've hired 2 attorneys, and so we wanted to meet at the city. I sent an email to the city that we were happy to meet anytime on Monday or Tuesday of this week. We would bring our engineers. They could bring their engineers. We will answer all the questions. I can't answer all the engineering questions. And by the way, we had 4 separate engineers work on this and approve things in addition to Mr. Thompson.
Were they all from the same firm or different firms, and did they all come up with the same conclusion?
Different firms. There was a geologist and an engineering firm from Geotech that did the geotechnical study, an engineer for geotechnical study. From that firm, there was a specialized engineer that did the hydrology study, and then we utilized Hill and Argyle and Telus to do the design on this. My partner is a civil engineer. He does this all the time. He did not want to do the design because it's, that would show bias. He did review everything, and it all came to what he thought it should. And then we sent it to Mr. Thompson as well. So I sent the email. There were some legal things I think that the city was looking out for. So we were available to meet all day Monday or all day Tuesday. When we didn't hear back, then I sent an email on Wednesday stating that I can still get everybody together, and would you like to see them at 4 o'clock today or any time before 11 o'clock tomorrow, which would have been this date. So we did make an attempt to meet with them, to show them all of the plans, but we did not give them, due to the concerns of the intent. Now we have since this morning, we have hired counsel, met with 2 attorneys. There was one that could not come tonight because it was such short notice. They have told us that it is fine for us to release those. So we authorize the city to release them. We will also give them to them if they would like. When I offered to meet, I was accused of trying to meet the city's grammar request. Of course, I'm not trying to do that. I'm just trying to get it done. There would be plenty of time for them to review it prior to the city council. But we'd received counsel not to, and then since hiring counsel, they have said that we can, so we will do that.
Thank you.
Thank you.
Say that again.
I'd like an additional minute. They went on quite long, and
Oh.
I think I just need to clear up a couple of things.
Okay.
Thank you so much. I know it's difficult being in the middle of all this, but this is a new plat in a new arrangement with Parcel 1 with the Briggs that they don't fully understand how they're connecting to 100 North Street and how that's going to be guaranteed. And just like they couldn't get their attorneys here tonight, we couldn't get engineers on one-day notice to review whatever he would be willing to show today, and to make sure that everybody was satisfied with a peer review that, in fact, these people who really would be the hurt and the people who would face the water damage wouldn't face it. So under these circumstances, since this is a new plat just from a couple weeks ago, it doesn't seem unreasonable after just a couple weeks of having this in the process, because this is something new in the process. This is not the preliminary plat. This is a final plat based on the preliminary plat. This is now another one. That it makes sense to continue to this. If you want to continue it to a date certain, that would seem to make sense. Give us a chance to get together, see if we can come up, perhaps with a mediator involved between the parties to make sure that everybody is being reasonable, that we're maximizing it so we don't end up with a mediocre development in Kaysville, which I found to be a very beautiful city, and that we end up with a development here that everybody can be proud of, and perhaps Mr. Prince will even come out ahead economically as a result of that, not just time-wise, but with how the development may ultimately look. So that's what I respectfully request, and I thank you very much for being courteous with all of us.
Thank you. Let's see if we have any questions that I think we kind of are getting the gist of it. So,
I'll start us off. When we originally discussed this, a motion was made with 5 qualifiers, and I think it would be appropriate for us to address those and see if we can kind of whittle away at some of this and get it down to just the core issues. Number 5 was that Lot 6 not be included. I think we're good with that. There's no Lot 6. We're done. I honestly, I just have to say, I don't understand the Briggs' position. You're being allowed access to property that currently is inaccessible and undevelopable. You can't do anything with it. The lots are too small. So we're giving you additional land, providing you access to the land so you can develop it. I'm not sure what the problem is there. That's just me personally. But I think that they have resolved requirement 1 that was provide access to the Briggs property. Access has been provided. So in my thought, that's been resolved.
I think that the Briggs felt like eventually the 100 North Road as a public road would perhaps continue, or that would be access, and it sounds like, if I understand correctly, that's what they would prefer, to have access to their property.
But still could not be developed. Their property could not be developed in its current form. Even if 100 was extended right to their property line, there's absolutely nothing they could develop on that, short of maybe building a shed.
I think the answer to that part, though, Tom, is just to I think illustrate what I think Lorene is saying, is if, let's just say hypothetically, and this may not be very realistic, but hypothetically this development was not before us, and the right-of-way is there. In fact, we saw a picture of it earlier, sort of the existing conditions, right, where the right-of-way cuts through and splits the Briggs' existing property. Well, I think their position is at some point they expected or hoped that right-of-way would get developed all the way up to the western edge of both of their parcels, and in so doing, they would be the right-of-way that is splitting their property would be deeded to them, and now they would have this contiguous piece, and the road would be right up to their western property line. So then they would have this whole piece with the road right up to it. Does that make sense?
Yeah,
I think that's what they're hoping.
Depending on the city deeding them the property.
Well, no, that's what happens when you close that right away. The 2 adjacent property owners get it, and that's the Briggs. Does that make sense? Is that accurate, Andy, by the way?
Yes, the adjacent property owners are entitled to the property and a vacation. The property or the roadway would still have to be vacated in the Briggs property, I think is what
Yeah,
Mr. Wood was
that's my
stating.
point. The city is under no obligation to vacate the property on the Briggs, between the Briggs properties, thus giving it to them.
But what I'm saying is if they were improving 100 North all the way up to the western edge of the Briggs' property, what interest would the city have in keeping that middle parcel?
Same argument can be made for the west edge of the Prince property.
Yeah, and I see that, but what I'm saying is I'm just trying to. Tom said, well, I don't see what the Briggs' problem is. Lorraine said, I think this is the problem, and I'm just trying to flesh out their position, and I'm just trying to flesh out what I understand their position to be as well.
And I understand that, but my point is they get it now, they have access to it now, they can develop it now, as opposed to perhaps someday in the future a nebulous date of a year, 100 years before the city's actually going to develop that. I mean, to me, it's the bird in the hand is worth two in the bush. You may have two in the bush 50 years from now. Take what you're getting. That's just my opinion. I think that they've resolved it. Number one, they've given access to the Briggs property. That's my opinion. The privacy concerns, the Ready Rock wall with fence on top of it and trees. I know there was an issue of the trees were slow growing last time, that it would take, they grow about a foot a year, I believe it was said, so it would take several years, but 6-foot privacy wall is about all we have expectation for, I would assume. Are there questions about that as to whether that meets the requirement that they were given?
I think with that, I look at really kind of what's standard, what's out in the market, what would be considered standard privacy. You go through most residential areas, and they're usually a 6-foot privacy wall. The fences are.
Right.
When you go to a main corridor, a main artery, it's not in our city, but you go to Lane Parkway, they've built the higher, taller privacy walls, but those are sound walls, as much as they are a privacy wall. So I think when you look at what's reasonably expected based on market, 6 would meet that requirement. And then just back on number 1 again, my thought with that, you both made good points on that, but I think when this was presented, unfortunately I wasn't here for that, but I've obviously have read and gone through the packet, and I've read the minutes, I've reviewed them. I don't think that was telling them that this speculation down the road, there might be opportunity. I don't think that was the intent. I think what the directive was they've got to resolve that issue. And from what Tom said, I would agree with that based on the directive that we gave and the information we had, they have given and provided access to that. And that's what the condition was that they provide access. It wasn't, down the road, this is the intent, what we might do in, 5, 10, 15, 20, 100 years. So I would agree. I think that they've met number 1 as well.
But can we just stay on 1 for a second?
And I want to do that too, yeah.
So can you just get a better, let's stay on this one, I guess. So, I think this is going to work. I tend to agree, but I'm to be honest with you, I'm on the fence a little bit. No pun intended, because I just want us to fully. Let me try to more fully illustrate what I think the Briggs' concern is. On one hand, I see what Tom is saying. Look, Briggs, you're getting a 30-foot by, if I read the number correctly, 122-foot piece of property for free. Let's just be clear. He said deeded to the layman. Deed means you get the property for free. Your title, your name is on the title. You get this property deeded to you. I'm not speaking for the developer, but I think that's accurate. That's what he said. You get this piece of property for free. You also get this piece of property that's was vacated in here for free. On the other hand, though, that means they have property
that they got for free, but now they have to pay taxes on, that they would not have, in their mind, had to pay taxes on if 100 North was never vacated and came all the way up to. The only additional parcel they'd have to pay taxes on is the part that got vacated up in this area. And so if we are saying, look, you get this parcel for free, we also have to recognize that, yes, they are also going to be paying taxes on this parcel. So I think we probably understand that, but let's just be clear that that's what I understand the one concern to be.
And that makes sense. We've got several different issues. We've got a Briggs-specific issue, and then we've got the other issue with the privacy wall and the water issue. To me, quite frankly, the water issue is the biggest issue. Then you have vacating the property, the street from the city. Mm-hmm. I don't, from what and I may have missed it in the reviews, but those were all, the vacating the property was actually a separate issue from, it was part of granting access. They had to vacate it in order to give them access, but I didn't see in the minutes, was it discussed on that, how the two correlate? So vacating the property and then also doing, this has changed from originally where it's moved.
Yep.
I guess just in my mind, trying to, because I understand he's going to pay taxes, but before, that was, again, may have never, ever occurred. So I'm just, did I miss something from them that didn't get into the minutes? I didn't listen to the audio, but I read.
Yeah, I mean, I think we had general discussions about it, if I recall. I haven't listened to the audio recently, but related to what you're saying, at least one comment that I had is it sounds like the Briggses and the Taylors and the Tices are well, I know that, of course, we received, I think it was an email from Ms. Tice that articulated their appeal. So they appealed, if I understand correctly, what they should have appealed if they didn't, and what I think they appealed was the City Council's determination on the final, or on the preliminary plat. And related to the City Council's decision on the preliminary plat was the determination to vacate the street. So to some extent, this goes to Mr. Bachman's point about let's get some conclusions of law and get the facts on the record. The ship has sailed, I think, for purposes of the appeal on the vacation. I don't know if you would agree with that, but I think the decision on whether to vacate those, what the facts are and what the conclusions of law were, or the rationale supporting the decision to vacate was back then. All we're saying now is we're looking at it and saying, does the final plat meet these four concerns, or the conditions, I should say? And so it's not really in our purview to relitigate, so to speak, the vacation. They can appeal that decision, but whatever we say now isn't going to be relevant to their appeal. And we're just saying, is the access resolved? Condition one.
Did it meet the condition?
Yeah.
Right.
Yeah, and in our last council or commission meeting, we talked that I think that's really kind of out of our hands now on that. That, like you said, I think that is settled. Right. And it was vacated, I think, from what I understand, so that we could get the access, and it helped. So it was really kind of, in my mind, the time is supposed to be kind of a win-win. It's going to help the Briggs to be able to get that access. It would help Mr. Prince being able to do his development. It was a separate issue aside from the other issues. But I think you're right. It's really kind of gone out of our hands. We really can't do much about the vacating, at least with this body.
So I have a little question about that same number one, and I am looking because the plan has changed along the way. So now, I mean, the point was made that it doesn't, 100 North does not, and maybe it's hard to read, but if it looks like you have to take a little jog onto the private lane and then make a left for wherever they may do like a flag driveway, right? Is that kind of what I'm seeing? Mm-hmm. So, And then there's an easement granted, and is the easement kind of a triangular piece that somewhat connects 100 North to the parcel 1?
And I don't think there is an easement shown on here that I can see.
See it.
So there was,
I mean, we're talking this area right here, right? And correct me if I'm wrong, there's no easement shown on the drawing, but you're saying there's an easement that's going to be contemplated for this little piece right here. Right.
okay, so there is kind of a jog where they will turn onto the private lane and then basically access parcel 1, which can give them a driveway to their flag, or is that the idea? Is it okay for her to clarify what she may understand?
Yeah. I just want to comment. I keep hearing about our lots are not buildable. Please understand, Lot 1 is not buildable unless the city gives the developer something for free as well. So that argument is relatively invalid, in my opinion. It should be across the board, and if everything's above board, I don't understand why we cannot see the records.
But that was never part of what we're looking at here. None of the requirements were provide records for adjacent homeowners.
Right.
We're looking at, did he meet the 5 standards really that we said? None of those standards were provide documents for the homeowner. So while I think that's a concern for you, great, you can work out between you guys. That's not really for us to decide because we didn't make it a condition.
Yeah, I think we've got an obligation based on what the conditions that we specified in that meeting. I think our obligation is to look at each one of those individually, as you're doing, to determine has he met those.
Right.
So, yeah, I'm just trying to understand exactly how it works. So the access is going to the end of the 100 North as it is now, turning onto that private lane, and then there'll be like a driveway coming off of it, if I understand the plan. And that's why it's just going to kind of sit until they're ready. They'll own it, and it'll just kind of becomes theirs to care for, to pay taxes on, and then eventually to develop. Okay, then I understand. I wanted to make sure I understood that correctly.
So just one more thing I guess I'll say on condition number 1, which again is the access to the Briggs property. And to some extent this applies to every single other condition. These conditions have some subjective aspect to them, but also some objective, so things can be determined objectively. So objectively speaking, is access given to the Briggs? Yes. I think objectively you have to say access is given. But does that resolve, sort of subjectively, does that resolve the concerns of either the city or the commission, the developer or the Briggs? And, that's where I suppose that's where the rub is. And, I'm inclined to say that it is resolved because, and I don't think this actually. Before I say that, before I say it is resolved, I think this was said in the past. I was not here at the last meeting, but I think it was said at previous meetings that the developer would be willing to bring utilities through parcel 1. I don't know if that's still a possibility, but then that would eliminate a concern that I think I heard in the past from the Briggs that if they just are deeded parcel 1 but there's no utilities in them, then they got to pay to put utilities in there. Whereas if the right of way was in all the way, in theory is the utilities would come all the way up. So that's a question I have that goes to the subjective aspect of Briggs of condition 1. If there are utilities, that are going to be provided, then we can even more objectively say yes, access is maintained and preserved for the Briggs. So I guess that's a question then. Are utilities going to be brought there?
Yes, that's correct. The utilities for 2 lots, whether they decide to do 1 or 2 at
all the way to this property line or just down to here?
Would you approach the mic for us, Spencer, so we can get it on the record?
Pardon me for not coming up here. It will be stubbed in here and here for 2 different lots. Whether they decide to develop 1 lot or 2, then they can. Because this is a double flag lot, I live on a double flag lot, and the utilities were stubbed to the beginning of the double flag, and that is the standard within the city. And then they're brought in. It's much cheaper to develop this because all you have to do is build a driveway, not a road. It's a driveway up. It also adds to the total amount of land, making the lots bigger and more marketable.
If I could just,
yes.
I mean, this is not at all in our purview, but if I'm throwing on my mediator hat, I'm saying I understand you're stubbing them here, but it sounds like you may be facing, almost certainly you're going to be facing attorney's fees that will probably exceed the cost of bringing those utilities all the way up to here, and maybe even exceed the cost of paving the road too. And so that may be something you could be conciliatory about and say, look, not only will, instead of the standard city requirement, stub the road here, stub the utilities here, maybe we'll, and I'm not speaking for the Briggs, I'm not even know if this will resolve their concern, but as a bargaining chip, bring the utilities all the way up here and pave it even. And then, I mean, other than paying taxes, what else can the Briggs be worried about there? So that's just an idea. And I'm not saying that's at all something that we should be basing our decision on. I'm just saying that's a nod to resolving this amongst themselves. But so anyway, but on 1,
Are there still
I would
questions
say,
on 1?
yeah, not for me.
I don't have any other questions on 1.
Okay. Why don't we move to number 4? We'll save the best for last. Work with staff to determine if a geotechnical report is needed. Andy, do you want to address that?
Geotechnical report was prepared and submitted to the city.
So in your mind, have they fulfilled requirement number 4 by submitting the geotechnical report to you?
Yes.
Okay.
And what does it tell us?
I mean, that's the real question.
Right.
Whether you submit it or not, okay, check the box. But what does it say?
The concern was, as I understood it, that the area called the low area of the property was visually had water on it frequently over time. The concern was what kind of soils were there, how deep was the unstable material that appeared to be on the top, what was the groundwater elevation in that area. The geotechnical report addressed those items, said that the topsoil and the unstable layer was less than a foot thick, as I recall, and that groundwater in that area was fairly deep. In non-technical, quick summary language.
Just for the record, we have to check the process. I mean, you're in deliberation. There's more fact-finding going on. You know, it just shows that maybe it's not right that everybody really understands all the different facts. So you actually have a harmonious neighborhood and happy people in Kaysville. But this is not appropriate to get into the fact-finding now after the public hearing is closed.
So anyway, how deep did they go down on that probe, on the technical? How deep did they go?
I know they dug a couple pits that were quite deep, yes.
And I mean, I appreciate the sentiment of what Mr. Bachman's saying, but if we're getting technical, there was no public hearing required by the city ordinances for this. Is that correct, Andy? For a final plat approval?
No, there's not.
So legally speaking, if we were just being technical, which I don't think we are intending to do, we didn't even there was no public hearing, and
We have emails from the city attorney where we were told that none of our rights had ended at any time yet, and so we didn't have to appeal, and that we would have an opportunity later on at this planning commission to be able to present present what our issues were.
And I think we've done that.
A 5-minute thing, so I would check with the city attorney on that.
Well,
there are communications where he made certain promises to us.
Sure. Okay, and I understand that, and of course, me individually or this body does not speak. We are just appointed individuals, and we don't speak on behalf of the city as a corporation or as a public entity. I'm just saying my understanding of the ordinance is at a final plat level, there is no public hearing required, and so I think we wanted to hear from both sides because these are important things, but that was not even required by the law, by the city ordinances.
Curious about whether this is Felshaw acting on this so far, or whether it's not been the new attorney yet.
We've consulted both.
Oh, have you?
Yes.
Okay. Thanks.
I also think, in somewhat response to that, we're discussing this as a commission up here. We're trying to go through these and do our job and our due diligence after hearing all sides again, going through. So this is more a discussion amongst us to help us to determine whether or not this meets the conditions that were put up on it originally. We're still back on the conditions that were placed. You know, and we aren't our
staff questions that we haven't had an opportunity to address.
But it's our right to ask them too, though, as a body. We can ask these questions of them. I'm not an engineer, you know, and so we ask. That's part of what we do. We have to ask. We rely on them for certain things so we can make educated decisions and informed decisions.
I'm just making my objection on the record. I'm not interested in having an argument.
Yeah, I think what we're trying to do is drill down into these a little bit and expand our understanding of it because, quite frankly, they met number 4. They worked with staff to determine if a geotechnical report is needed. Check. We're just trying to flesh this out a little bit for our own understanding and for everyone that's here. If we go technically, they met it, you know, hit the gavel, Betty, and that one's done. But we want a better understanding and deeper. We're not here to tear apart the geotechnical report and determine whether everything's going to meet every standard that's ever been set. We're just trying to see if we can learn a little bit more about the process.
Well, but with respect to the geotechnical report, we as individuals just aren't expected or able to review the geotechnical report, so we rely on staff to do that, and we ask staff, Andy, in staff's opinion, after reviewing the geotechnical report, does it look to be adequate with what the city would be concerned with? And I think the answer to that is yes. Is that correct?
It addressed the concerns, yes.
Okay. So, I mean, that's all we can go on. Now, I realize there are rights of appeal, and they can do that all they want, but as we are sitting here right now, we can only go on the limited resources that we have from city staff, and it sounds to me like it was adequate.
Agreed.
Not only was it given and determined that it was necessary, it's adequate with what the city is concerned about.
Which I believe brings us to number 2.
Yay. Okay.
Oh, you skipped 3. You're going to go back and forth?
Well, we talked about 3 a little bit.
Okay.
Just whether a 6-foot fence, and I think, Gary, you addressed that's pretty standard. It's different in some locations, like Layton Parkway, where they may have a higher or thicker wall or something like that.
And there might be some HOAs, too, that may do it, but I don't think I've seen any that have required higher. But, I mean, just a standard, you know, and what's normally accepted or expected, I think that's been met. And they stated that even from a seismic standpoint, the retaining wall, they've seismically looked at it. They've looked at it, even the geotechnical aspect of it, and then they're building on top. You know, the trees, you know, that it takes time. It'd be nice to have full mature trees. I wish I had full mature trees when I planted mine, but. And the spruce, if I understand, they not only grow tall, but they get fairly wide, so that they do add some privacy to it. But we all understand it will take time for that to grow to where it probably provides even more privacy. But from what standard, I think they've met standard.
And I think the concern on this one, of all the conditions, is this one's probably the most subjective, and the one person that or family that matters most on this would be the Taylor's subjective opinion. And I don't know that they'll ever, if this is satisfactory or not, it may be unsightly, and I can understand that. But does it maintain privacy, lines of sight into their home? From what I've seen, I think the answer to that is yes. And so we can only go so far in addressing reasonable conditions to maintain privacy. And I think I would agree that I think, although it might not be ideal from the Taylor's perspective, I think that this has maintained privacy as much as reasonably expected for this development.
I do have another question just to clarify. You mentioned it'd be cobblestone or limestone retaining wall. I think you addressed what the actual fence materially would be. I don't recall seeing that or talking about that tonight.
Yes,
what would that be?
The fence material is to match the fencing that they have on their property.
That's right.
So long as it's available. We will, if the same fencing's there, if not, we'll match as close as it can. But if that company is still in business, we will definitely use that company so that it matches.
And are there options and colors of it's the Ready Rock that you use as the
Ready
retainer?
Rock. There's several options of different designs. The two that we landed on were either the cobblestone or the limestone. They're
So
just
that's
a different
the
design.
Fence, not the retaining wall.
That's the retaining wall.
That's the retaining.
That's retaining
The
wall,
fence
yes.
goes on top
and
of
that's
that.
Ready Rock, and those are used by municipalities. They're very. I wish I could afford that on my property. It's a very, very nice retaining wall. It's way better than a slab. The current retaining wall that's on the parking space on their property is a slab one here, and then so I think it's a beautiful retaining wall.
And so does the current one stay, and then this is added?
Yes.
Yes.
In our Alta survey, we found that the Taylor's retaining wall for their parking spot is actually on our property. We are not going to remove that or cause them to remove it. We will be putting our retaining wall outside of that and granting them permission to use that. I think that would be petty for us to have them, go the 1 foot that it's extending into our property, and ours I think is 11.5 inches, and having them remove it. There's no reason to do that.
So you mentioned granting them permission. Are you going to actually deed that over to them too then?
We were told by the surveying company that you don't have to deed it. You can grant a written, even verbal, but written permission. I planned on doing it that way, so that no one can come in and say you have to tear that down. But the retaining wall will be built in front of it anyway.
And there's two options then that you've landed on, you say, right? And
yes, that's correct.
would you allow them to decide if there's a preference for one over the other?
Yes.
Okay. And then I had a question about that, but it's not. It has to do with number 2. So
can we check off number 5 and only have 2?
I think we're good to go to number 2.
Okay.
3. Yeah.
Let's talk about 2.
Okay. Well, maybe then that was it. So thank you for answering more.
No problem.
So I'm very curious about the slope question, that it actually currently slopes to the east, and yet they've had water coming down there. So if it slopes, but water is currently coming down there, can you explain that a little bit? And will the new retainer help? I mean, just explain a little more about that particular place, and then I'm sure we all have other questions about the water.
That was a very important subject for all of the engineers. We not only did a geotechnical study, but we did a hydrology study, and then it was emphasized with the engineers that designed our subdivision. The stream used to come down and go right through the middle of this property. The builder that built there built this property fairly low. This is low here. So water does flow downhill. What we have done is built that up so that there's not only a slope from the top of the retaining wall to the east, but then the road is raised and the water does not flow. All of the water on this property is directed down here, then up through, what do they call those? A pipe. Up through a pipe.
It's technical.
to the detention basin. And we did a dual purpose with the detention basin, not only to detain 50 years, 5 times what the city requires, but also if there were ever any problem here with where the stream enters the culvert that the city put in, then it would overflow. It would come into here because the top of this and this property is approximately the same that we're doing. This has been a maintenance issue in the past because there's an open space between as part of the stream. The stream comes down, it's open on Mr. Briggs' property, it goes into a culvert, then it's open for 15 feet, 20 feet or so, and then there's a very fine grate that's right here on the city property. That fine grate gets plugged by leaves. So when that was happening, then that would redirect the stream out into here rather than go down because it was being plugged. That grate will not be there. This is not the same kind of grate up here. This is a grate for logs and things like that. As it does on every street in the city, those things will just flow in and flow down.
Is the retention basin an open basin?
I'm sorry.
Is the retention basin an open?
Yes, it's an open basin.
So there's no underground tanks anywhere in this
correct
development.
That's correct.
To retain water. Okay.
Yeah.
So if I understand you correctly, it's the property is already sloping toward the east.
Yeah, maybe I'm not. Maybe I should explain better. The property slopes to the west currently.
Okay.
The engineers, through grading and design, God, I'm sorry, my mind's going blank, but through design are raising all of this area in here. So
ultimately it will slope to the east.
How high or tall do you have to build that?
Well, they're constrained somewhat by the elevation of this.
Yeah, right there.
Right. In fact, that's what sets everything. Is the elevation of this.
Generically, the road will be the low point on the property, so all the water will drain to the roadway, or it can then be collected into the storm drain conveyance system.
The private road.
The private lane
will be
yes.
the
will be the low point.
Will be the low.
Yes.
And Mr. Larson just corrected me. It does slope to the east, but after the curb, there is a slight slope to the west. But this waterway is designed to take all of the water from the west and from the east and directs it up here and into the storm drain. Could you hear me? I was talking away from the...
Yes.
Yeah, and I do remember you saying something about that the last time, that you are designing the private road to be a collector
correct
of the water.
Not only a collector, but it's also a barrier.
A barrier, too.
Yeah, there's not... it's higher and will not allow water to flood down through here as it did in the past.
And will you just, and maybe this is better for your engineer, or maybe Andy can explain this. If I heard you correctly, one is the volume requirement that the city cares about for this detention basin is a 10-year storm. you've designed the volume for this detention basin as for a 50-year storm, and you've implemented some mechanism to deal with water in a 100-year event. Is that correct?
That is correct.
And the 100-year mechanism is some overflow in this corner that is able to handle that additional design storm.
That's correct. And part of the reason for that in the 50-year event is the abundance of caution by Mr. Thompson, requiring us not only to detain all of the water for our property and detain all of the water for Mr. Briggs' property for when he develops. That's what said it. But we meet that with the 10-year here. Then he, out of abundance of caution, requested that we detain as much water as this used to detain, and we've added that to that. In the end, that's a 50-year event, but the ultimate outflow through the storm drain can handle, I think it's 10 times what a 100-year event is. But whether it's a 100-year event or 3 times the 100-year event or 10 times the 100-year event, it can handle it.
Maybe my engineer side is wanting to see some contour lines, but whatever. Andy, is everything that I've said and what's been represented, is that accurate to your understanding? And from an engineering perspective, you're confident that this design handles well beyond the 10-year design storm that the city would require. Is that accurate?
Yes, that's correct.
Okay.
That reminds me of another question from the original sharing you did. So, and I remember you said this the last time, that one of the drains on the Taylor's property will no longer be needed.
To clarify, we had a drain here on our property that flowed through the drain on the Taylor's property. They have one on this side of their home,
yes,
and one in the front of their yard.
Yes.
So we were adding to the flow through those. Those grates and that storm drain will remain exactly where it's at. It's on their property.
Yeah.
But it will be terminated on the other side of the retaining wall because we're no longer sending any water that direction.
So it only handle the water from their own property?
Correct. So and they're good size grates as well.
Yeah. Okay. That helps to explain that. Thank you.
Okay.
Any more questions?
Just to state what I think I understand is that the hydrology study was for quite a large area, right, Andy?
Yes.
28 acres.
Generically what they determined to be the drainage basin for that location.
Uh-huh. Yeah, I just wanted to emphasize that because that has been very important to us, that we understand where all the water is and goes and flows.
And that actually kind of gets to my comment on the contour lines, and that's why I'm just trusting Andy's expertise, because to me that seems like this entire, unless it's a really deep detention basin, this entire lot would have to store that amount, the volume of a 50-year storm, in just my gut reaction. But that's why I'm saying if Andy's comfortable with it and he's reviewed it and he feels that it meets the requirements or exceeds them, actually is what it does, then I'm comfortable going with. I'm comfortable saying number 2 has been addressed in my mind.
I have no more further questions.
I still wish that, it just sounds like the communication has been strained and very difficult. And, I'm sorry about that. This is very rare for us to have as my 4th year as planning commissioner. We've really only had a handful of quite difficult challenges with a development or a change in my tenure, and this is one. So, you know, I think we all kind of sympathize with all sides and all perspectives. It's been challenging. So, and it's challenging for staff, and it's challenging for us, and so I think we just have to recognize that this has been a really hard one to kind of wrap our heads around and everyone do the best you can. So I was really wanting to say that I wish in a kind of a better climate of cooperation and without, you know, all the angst, which I can understand the angst, that they'd been able to review, you know, the latest of the studies, because we certainly hope that this is very encouraging, that you know, this will make things better for the decades to come. So that's what we would like. To me, that's my fellow commissioners have stated it, that our responsibility is to look at the laws that exist and then to follow up with the conditions that were placed with the previous meetings, us and the City Council, which is the legislative body. And so we've tried hard to go through all of those things. To me, the missing thing that perhaps could have helped and could still help is time to be able to look and make sure that the neighboring property owners, you know, that could perhaps avoid an appeal. So that's my only last thing that I kind of really wish could have happened, which you requested, which there's, you know, legal advice and, you know, difficulties I can see. So that's my assessment at this point of, you know, a lot of time and effort on everyone's behalf.
Can I just say sort of a summary of my last position? And actually, this is an effort to, if this decision is going to be appealed, this is an effort to give some concrete reasons why I am going to vote the way I'm going to vote, and then I fully trust the appeals process, but at least they will know the reason, the rationale behind why I'm going to say each condition. So let me just go through quickly. Number one, before requesting final plat approval, access to the Briggs property be resolved. I think access to the Briggs property is resolved, in my opinion, because Parcel 1 gives them it gives them physical access to their property. They are not becoming an island. They are actually being deeded land that will physically allow them to walk, drive, bike, hike, whatever, physically onto their property. They are not being isolated from a city right-of-way, in my opinion, and nor are they being isolated from the utilities that would exist in a city right-of-way. So physically speaking, access is given to their property. That's one. Two, stormwater problems are addressed. We've already just barely talked about that. My reason why I think the stormwater problems are addressed is because of the staff's review of the plat and the engineering that has been submitted. Our city engineer is telling me in his review that it meets and exceeds the design storm and requirements of the city. So in my mind, it is addressed just based on that reason. Privacy concerns are addressed. Again, this is subjective, and so if I'm trying to see what a reasonable person would think are privacy concerns, one of them, as I mentioned, was views into the Taylor's property. I think the views are addressed by the wall and the fence, and then an additional layer would be the trees and the setbacks of the buildings are 60 feet is what I think I heard. that, in my mind, all of those things aggregated together addresses the privacy, maybe as best as reasonably can be expected. And then the geotechnical report requirement, it seems to me that it was determined that one was needed, one was submitted, and staff, again, reviewed it, and it seemed to address any concerns that the city would have with geotechnical problems, and that is a reason why I think that condition is addressed. And then number 5 is off the table. So those are my reasons. Those are my rationales to support why I think each condition was addressed.
Do I hear a motion in that?
So, I mean, if there's no other, yeah.
No, because I agree. I stated in last meeting that it was even quoted in the letter that if they met the conditions, I would vote in favor of it. And I also, going through this, it may not be ideal under all circumstances for all parties, but I feel that the due diligence and the information and what we've been given, they have met the requirements as well. And with that, I will go ahead and make a motion that we recommend final plat approval for the Whisperwood Hollow subdivision, previously reviewed as Whisperwood subdivision, for Mr. Spencer Prince at 650 East, 100 North, R18 single family residential.
I'll second.
Aye.
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 With that, I would like to make a comment that, ours is a recommendation. It goes before the legislative body, the city council, for this. I would highly, highly recommend and suggest that there is some get-together where you do have the opportunity to review some of those. I believe that the staff has reviewed and looked, and their engineers are certified. They know what they're doing. And I trust their opinion, as does Mr. Sunloff. But I think that it would be advantageous for you folks to be able to have that opportunity, and you've stated that you would be willing to do that. So I think that would be at least a recommendation I'd make, that hopefully there can be some consensus and some comfort and some reassurance to you guys.
May I follow up? I think there's one fact.
Could you?
Not affecting trying to affect your decision. Okay, but just on your comment, because I think it's a positive comment. What I've heard in some of the anxiety you've had here about the neighbors not being seeing the documents and what's happening, is what I heard is that this is going to the city council next week. And see, that doesn't allow enough time to get together and to verify that everything you think, is fine, that the neighbors get to see that as well. And how it's going to work, how the access to drainage and everything else. So we really need that time before the city council meeting, and that will help, I think, bring peace to the community if everything comes up just like you said.
I'm not sure when the next
meeting. When is the next meeting?
Is.
I would expect that this will be on next Thursday's city council agenda.
Have they decided they will meet?
They will have that meeting on December 21st.
Okay.
And it's just a recommendation. It's not a requirement. It's the city council doesn't. They may require it as one of their conditions. I can't speak for them, but I'm just stating that it's not a requirement of us. It's not a stipulation or condition we're placing. It's just I know this is an emotional issue. It's a concern, and it's just a recommendation that if you are able to get together, but otherwise it will proceed.
It will proceed unless somebody overrides that. That's the normal process. That once it's approved or has a recommendation from the planning commission, it goes to the next regularly scheduled city council meeting. I'll also say that I will immediately distribute plans upon either being advised by my legal counsel that it's appropriate or by receiving permission from the owner of the plans.
Both of those things you'll need?
No, either one of them.
Either one of them?
Yes.
I guess, does it have to come from you? Or Mr. Prince has already said
If
he
Mr.
would
Prince would like to deliver the plans to them himself, essentially that's the problem we had, is they're his plans, they're not our plans to distribute.
And again, I just want to reiterate, it's not a requirement, it's just a recommendation.
We can send them electronically tonight or tomorrow, whichever they would like. I just need to get the information.
So maybe you guys exchange emails.
You can send it tomorrow. Either way.
Well, I think, Andy, you'd still have to get permission from our city attorney, wouldn't you? Even with his granting permission, would you still need?
No, he's already told me that if we have permission from the owner, then it's
okay.
It's okay.
He'll be sending them.
So we have
if
him
you'll
on
send me an
record
email
granting permission
tonight. Given that permission, I will forward the electronic copy of the plans to all the parties that I'm aware.
Okay.
I mean, these are plans we could have had 2 weeks ago. Does the city council not meet every week? Is there some way the city council could meet 1 week later and allow for adequate review and people to be comfortable?
That's their decision.
That's the city
that's out of
council's
our hands.
discretion. The planning commission cannot do.
Yeah.
And it is typical.
People try to get together, and it doesn't allow enough time.
Okay.
I'm sorry, I'm not on this. You're, basically chasing out some very good neighbors. There'll be people moving due to this development and the lack of moral compass that I have seen here. I'm very, very disappointed. I have always loved Kaysville. And Mr. Sundloff, I'd like you to understand what the Taylors have been through since that house was built. All the geotech studies were signed off as well. That's cost the city and that family a great deal of money and problems. And so to take a house and do that here, there were mistakes made, and not consider that right next door, I think is a very large mistake.
Okay.
All right, next item.
All right, we'll go on to the next item. We have a final plat approval for Sunset Equestrian Estates at 1950 South Zenwata Way for Symphony Homes.
This is Sunset Equestrian Estates. I think we're reasonably familiar with it, out on the southwest part of town. This is just about the last phase of that project. They've just completed the north road up to here. This area is all built in the middle. This is the church that's been there for quite some time. So phase 16A will continue Zenyatta Way to the north and tie in with whatever that road's called. I can't read it. Palomino Drive, I think. Complete that section. There is still one additional phase, just a cul-de-sac that fits in this little area right here. But this road will be completed across, and then phase 19 is a cul-de-sac on the end. This part was rezoned just earlier this summer to an R1 LD zone. And they've now platted lots on that. You've seen the plats. This is the 16A. It's virtually identical to the preliminary plat that we've been looking at for several years now. We did amend the development agreement to provide a stub road here rather than the 90-degree corner to access that additional property on the end. Final plat for phase 19 is the R1 LD. The lots, I believe the smallest one was around 18,000 square feet, so it's just barely under the 20,000. The biggest lots in the back are well over 30. They all well meet the zoning requirements. They're very much in compliance with the preliminary plats and what we've expected to see here. The engineering is in good form, and we're ready to recommend final plat approval for both these phases of Sunset Equestrian Estates.
We remember you.
Thank
Glad
you.
to be here. I'm John Wheatley with Symphony Homes at 526 North, 400 West in North Salt Lake, and we're glad to be here this evening. And we have enjoyed working on the previous, I guess it's 80 lots about that we've done out here in the previous 6 phases. So we're glad to complete this. Just one note. There is a section that Mr. Belknap owns, but we are stubbing the utilities off the road we do into his lot, so the road won't have to be opened up in the future. We have an agreement with him to do that, and so I think it should go smoothly, and we're sad to see it's almost done. If you have any questions, I'd be glad to answer them.
Pretty straightforward.
It is.
Yeah.
If this, this is Christmas time, this ship has long sailed on this one, but I would have loved to have seen the road connect right there, but oh well.
You wishing for Santa to deliver that?
Because that just really isolates all these people. They have to drive clear over here or way down and around.
Yeah, maybe you can describe how that was in the past.
Though, based on our last meeting, we probably don't want to argue traffic going through a neighborhood.
I can speak briefly to it.
Disabled kids standing on the
There was a
streets.
group of partners that included Mr. Belknap, and his neighbor there wanted some land and doing that, and there's also a ditch that runs through there, so he wanted to just sell us the 4 acres, so we bought the 4 acres from him, and he's doing something else with the other 2 acres with his neighbor and other partners up there. So that's how we came to that, and that's why we previously had the master plan amended so there was access, at least from our parcel, to this. I appreciate your comment on.
And Palomino Drive meets the requirements for fire and life safety for the cul-de-sac, right?
Yes.
Yep, you are right, Josh. That would have been great.
Just slight offset. We did get a trail, so there's a walking path directly to the
School.
The 2 schools,
which is nice.
They're out either Sunset or Angels.
Mm-hmm.
You can't drive where you need to go, but you can at least walk to school now.
Okay.
Yeah, I remember that. That was brilliant. Well, I move that we recommend approval for Sunset Equestrian Estates Plat 16A and 19, the final plat, to Symphony Homes, 1950 South Zenyatta Way.
Second that.
Aye.
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 Okay. We have another final plat approval for Bob Mason subdivision at 860 South Roche Lane.
Mr. Mason called us earlier and indicated he'd be out of town tonight. Asked that we put it on the agenda, feeling it was fairly straightforward. Looked at this property recently and rezoned a portion of it. What did we rezone that to? RA. He submitted a preliminary plat at the time of rezone, which was approved. He's now submitted a final plat. Actually, this is the preliminary plat that we reviewed. The final plat looks very similar to that. It has roadway, a private lane coming in, turnaround at the end. Currently has a large barn on lot, I believe it's lot 1. Would create 2 new building lots. He could also build a residential home on that lot in the future if he chose to. One thing that's a little different than what we typically see is the private lane goes through the middle of the property and the lot rather than along the edge. It works fine for the back 2 lots. Little odd in the middle. The reason for that is that's where the driveway is. It came along the edge of the property initially and then came into his barn. We reviewed that with him. That lot that's platted on either side of that driveway has buildable area adequate for a more than reasonable house on either side of that road. Private lanes can be easements through the lot, included in the lot, so that it's not that it's splitting the lot in half on paper, but physically it clearly is. So there's that issue. Other than that, everything is well within the requirement. And we feel that the property owner is aware of the impacts that may have on the property. It still very much is a buildable lot. Frankly, we envision that they'll build a house probably on one side and maybe a barn on the other side of the road, and it could be very functional in that manner. So We feel like it meets the requirements, and we're willing to recommend final plat approval for Bob Mason subdivision.
Andy, that ends in a cul-de-sac, not a stub road there, doesn't it?
That is a cul-de-sac, yes. There's nowhere for it to go.
I'll make a motion that we recommend approval of the final plat approval for Bob Mason subdivision for Bob Mason at 860 South Roche Lane.
I'll go ahead and second it. Aye.
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 All right, we'll do a call to the public.
Our public declined.
Oh, okay, well, welcome. Okay.
Welcome to the end.
Thank you. Any reports?
Yeah, so to start with reports, an item that's been brought up for some input and comment and feedback from you. Mayor-elect and city manager have been looking forward to the upcoming year, looking at their calendar and meeting schedule, and have asked for input regarding potential meetings on Tuesday evenings with the Planning Commission rather than Thursdays. It'd still be the second and fourth week of the month. And so we're hoping to gather feedback on that to help them determine
that's
whether
what
or
it
not
used
that's
to be.
feasible or something they can do. So.
I don't,
Oh, City Council.
City Council was. We had this discussion a couple of years ago after the last election cycle, and we actually had a work meeting, if I remember right, the council. And I know I can't do the Tuesdays. I stated back then that we were appointed. We kind of knew what we were signed up for. It's a little different than an elected official that really kind of meets it, but my preference would be to stay to Thursday. Tuesday nights I wouldn't be able to commit to that.
I'm curious, what do they think that improves?
I don't know if they know of any improvements for the Planning Commission perspective, but as far as accommodating different meeting ability for the City Council itself is my understanding of the reason for considering Tuesday nights.
Considering having a work meeting
in between
on the
theirs.
off week that they have their regular meeting to.
Yeah, last time it was to give them more time to review the packet
Right.
because they didn't think there was enough time.
Mm-hmm.
But that seemed to not be a kind of a non-issue for most of it.
And at this point, they strictly are looking for feedback and information. It's not a done deal by any means. It's my impression.
We've given them plenty of feedback internally, but we would appreciate yours as well.
Uh-huh.
I suppose if I had to, I could make it work, but I'd lean more in Gary's camp on that one. So Thursday is a much better day for me. And I think the incidence of me not showing up would be higher or more frequent on Tuesdays than Thursdays, which I think has been relatively low, but of not showing up.
And couldn't they still have a work meeting on the Thursdays?
I suppose there are any number of ways it could be done at different times and so forth. So
Yeah.
No, that's just simply one of the ideas was if we just meet every Thursday as a council, have the work meeting one week and the regular meeting the off week, or vice versa, whatever.
Oh, so the point is because we are using this physical space where...
Well, and we even discussed having one body meet in the police station and one here.
Yeah, if they're just having a work meeting, that maybe they could be over there.
The problem is if they're having a work meeting to discuss the upcoming issues, you're discussing some of those same issues in your meeting that they want to be preparing for their next meeting.
Mm-hmm.
And so they don't have input at the work meeting from the Planning Commission.
Mm-hmm.
So there's pros and cons to any formula you come up with.
Do they currently have a work meeting every other week?
They have not done that in the past
Boy, I
on a
hope they get
regular
a
basis.
raise.
And just curiosity, is it required that work meetings be public meetings?
Yes.
Okay. Anytime they convene to discuss things, they have to be public. Got it.
Yeah, they have to be open to the public.
Yes, right. That's what I mean.
The council used to meet on Tuesday, right?
Yes, they did.
So, okay.
Okay.
I'm fine with either evening.
I am too.
I prefer Thursdays.
Thank you.
Oh, wait a minute. I got a text from Stroh, Matt. They prefer Thursdays too.
Well, hey, look, we already had a majority, so.
Yeah, there it is.
They're watching us live because they hate not being here.
Just other quick report for your information. The City Council did review the subdivision, Whisper Creek private lane issue. The council did not agree with the Planning Commission's recommendation. They approved preliminary plat subject to a public street connecting those two roads together. Since you gave a recommendation for both preliminary and final plat, it will not be coming back to you for further review. And the final plat will likely be on next Thursday's agenda for the City Council.
I'm guessing I haven't heard of it. It's probably the public right for the streets, to access to streets. Was that what it was? Versus, because we were closing it off and making a private road. They want to keep it public to have public access.
That'll be a fun one.
Yeah, the concern was, I think, with circulation in the neighborhood.
And the fire chief still just wasn't really liking the idea of the gate.
The fire chief was not fond of any gate proposal. Another argument is, do I get to come in next week and say, got too much traffic in front of my house? Can I make a short segment of it private and then put a gate in? Roads are meant to be a network and distribute traffic evenly among all users. So those kind of reasons. So just so you're aware.
It's only happened a couple times that I remember, but that's why we have check and balances.
If they did everything you said, we wouldn't need both bodies.
Yeah.
Exactly.
What was the vote? Was it majority or was it split or
4-1?
Okay.
It's understandable. That was a
Yeah.
Yeah.
it was kind of
Could go either way,
kind
kinda.
of. Half a dozen of another.
Well, unless there are reports from the Planning Commission onto our calendar, unless you would like to come here. I don't think as staff we're planning on being here on the 28th, so we will be reconvening in January. And for now, we'll assume it's on that second Thursday, which I believe is the 11th, unless we inform you otherwise.
Okay.
Did we ever hear on the puffer?
Oh, I saw in the
Appeal?
paper today that they had enough signatures, right?
Yes, the
They were on KSL 5.
referendum was certified, received enough signatures to qualify.
So then we'll be hearing the appeal then?
Potentially, yes.
I've heard some
But
rumors that
there's
they
been
were
some
trying to negotiate.
negotiation between Mr. Puffer and the neighbors that are opposed to him being there. They've been trying to work out some deals. We were advised by our legal counsel to kind of let that take its course.
Mm-hmm.
I'd agree.
Essentially, as a landscape facility, it's not being used this time of year anyway. So we're watching it close. If negotiations break down or there's something that resolves it, then we'll either not need to hear the appeal or we'll get it on the agenda and take action as appropriate. So again, we're following the counsel of our legal advisors on this one because
Did you hear that it was on Channel 5 night before last?
I didn't see
They
it.
interviewed the citizens.
To me, that means it's a really slow news day.
Yeah, I think so. Old
I agree with
Kaysville's
that one.
piece. Funny.
Okay.
Or somebody called. I got a story.
Exactly.
So the city, you're not missing the city gathering tonight. They moved it, did they? No. Oh, it is tonight? Oh. Oh, gosh.
Where was it at?
We're at
Police
the real
station?
party.
Oh. Well, you might be able to get the last 15 minutes of it, maybe.
In that case, I make a motion that we adjourn.
Okay.
So moved.
Thank you.
Thanks.